Thank you all for joining us today. My name is Chell Miller. I'm the publications editor and community events organizer at the Government Law Center at Albany Law School. Before I turn things over to Patrick Woods, I wanted to share a few housekeeping notes. CLE forms and program materials have been sent out to everyone by email. If you have questions about CLE credit, you can contact Lisa Rivage at lriva@albanylaw.edu. I will put her email address in the chat, but you should be seeing it on the screen. Throughout the program, if you have questions for guest speakers, please click the Q&A button at the bottom of your Zoom window and you can type in your question. We will be monitoring questions throughout the program. If you have any additional questions or if you have any trouble, please contact me by email at cmill@albanylaw.edu. And another quick note about CLE, there will be one CLE code word shared during this program for those of you who are seeking CLE credit. And at this point, I'm happy to pass off the baton to Patrick Woods, Deputy Director of the Government Law Center.
Good afternoon. As Chell just told you, I am Patrick Woods, the Deputy Director of the Government Law Center here at Albany Law School. I am very pleased to welcome you all to the fourth and final program of the 2023 installation of the Warren M. Anderson series. Right off the top, I'd like to say thank you to our series sponsors, Greenberg Traurig, and family members George, Charles, and Joan Weissman, supporting in memory of Sharon P. O'Connor, Albany Law School class of 1979. Our mission here at the Government Law Center is to help state and local governments better serve their communities by providing nonpartisan legal research and analysis. We bring together a diverse and inclusive group of lawyers, students, scholars, and community partners. We prepare students for careers as attorneys in public service. We advance Albany Law School's unique connection to government, and we inform nationwide conversations on government and the law. We have a very distinguished panel of speakers today on the timely and important topic of the New York courts during COVID-19 and beyond. The moderator of today's program is the Honorable Leslie E. Stein, Director of the Government Law Center and recently retired Associate Judge of the New York Court of Appeals. Just to echo something that Chell said, but is I think important to all of you seeking CLE credit. As a reminder, there will be a CLE code word announced during the program. You will need that code in order to receive CLE credit, so write it down. I will now turn the program over to Judge Stein, who will introduce our distinguished panelists.
Thank you, Patrick, and welcome everyone. Good afternoon. As a former judge and member of the Commission to Reimagine the Future of New York's Courts, I am very pleased to moderate today's program on a topic near and dear to my heart, the adoption of methods, technological or otherwise, to improve access to justice through our courts. Many changes have been made in the operation of the courts since the onset of the COVID pandemic, and numerous additional changes have been proposed as a result of the pandemic and other events affecting the courts. To address some of those changes, we are fortunate to, as Patrick said, have a very distinguished panel with a variety of backgrounds and perspectives. In alphabetical order, the panelists are first, Jessica Cherry. Ms. Cherry is Deputy Counsel for the New York State Unified Court System. She's also a member of the Commission to Reimagine the Future of New York Courts Pandemic Practices Working Group. That's a mouthful. In addition, she has been appointed to the Office of Court Administration's Blue Ribbon Panel to implement pandemic-related innovations aimed at enhancing the delivery of justice. Honorable Craig Doran is a justice of the New York Supreme Court in the 7th Judicial District, covering 8 counties in the western part of the state, where he has held a number of judicial and administrative positions in the court system. Judge Doran is the chair of the Pandemic Practices Working Group of the Commission to Reimagine the Future of New York's Courts. And last but certainly not least, the Honorable Fern Fisher is currently an attorney for the Legal Hand Call-In Center, Special Assistant to the Dean on Social Justice Initiative, and a visiting professor at the Maurice A. Dean School of Law at Hofstra University. Judge Fisher has a long history as a judge and administrative judge in the New York State court system, and before that as a legal services attorney and director of a legal services program. We will begin the program with some remarks from each of the panelists, which will be followed by a discussion. We hope to leave a few minutes toward the end of the program for questions from the Zoom audience as well. So let's get started with Judge Doran.
Thank you. Good afternoon, everybody. I am thrilled to be with you all, and there's a couple of reasons for that. I'm a huge fan of Albany Law School, of course, some of my best years there, and love the contributions that the law school makes to our community and to government in particular. And the panelists that I have the privilege of appearing with today, and I regret that we're not in a room together, because that would absolutely make my year if I could be in the same room with these folks whom I admire so much. Judge Stein, Judge Fisher, and Jessica Cherry, all of whom are folks that I've had the opportunity to work very closely with, and who I appreciate so much, particularly as we talk about the challenges we face moving forward. So I have about 10 minutes, and I'd like to use that time to go through a PowerPoint. And I apologize, I am going to go through it fairly quickly, but I would really love for our audience to be able to get a feeling for how unique this effort has been for a number of reasons. The most significant of which is the process. And I've been in government for most of my professional career, and frankly, I've never seen anything like this. And there are so many reasons why. One of those reasons is we were doing this in the middle of the pandemic. Really, when we started this process, thanks to Hank Greenberg and the Commission to Reimagine the Courts, and also Judge DiFiore and Judge Marks, who commissioned this process actually as we were emerging from the pandemic. So it gave us a very unique opportunity to study in real time what was happening with the court system's reaction to the pandemic. I also had the privilege, along with Judge Canatero, to work on the court's reopening, so to speak, starting back in the very early days of the pandemic in 2020. As we began to return to normal at that time, we had no idea how long the pandemic would last. And we were really day-to-day learning from our experiences. So for so many reasons, this process gave us and continues to give us a very unique opportunity to do some very positive things. So we formed the Pandemic Practices Working Group, which, and Shell, I'm going to ask you to go to the next slide, which okay, it's the next slide after that, I apologize. This is the first of two slides that shows us the members of this working group. Not a single soul that was requested to be part of this said no. And as you can see from this list and from this list as well, we had an incredible group of judges, of court administration officials, of access to justice advocates, practitioners, criminal, civil, commercial, etc. I'm certain that all will agree that this is a rare group of folks that represent this tremendously large and tremendously diverse state. We set out to do, and this is our mission, really twofold. One was to study or review what the court system had done and was doing to react to the pandemic and to continue to provide access to our courts. The other was to make some suggestions as to what we ought to take with us into the future. And I think most agree that we should certainly learn from what we did right, what we did wrong during the pandemic, and we should make sure that we hand off to those that will be leaders in the future how best to react to these situations in the future. So that was the second component of our mission, in addition to making recommendations as to what we would like to see continued, but also make recommendations to the folks that will be leading our justice system in the future, how best to assure that the courts continue to function and the system continues to function. And I hate to say when, I'd rather say if, but I think we have to plan for the the contingencies that we know are a virtual certainty that we will in the future, whether it be weather, whether it be technological issues, some sort of interruption to the court system. We need to be prepared for that, and we need not to reinvent what we've already learned from. So there's the mission. If you go to the next slide, please, Chell. So we set out to do an honest, open, transparent review of what we did during the pandemic. And it was our mission to be as inclusive as we possibly could to this extremely complex judicial system, but to make sure that we heard from everyone we could possibly hear from, anyone that would possibly have an interest in expressing a view as to how we did during the pandemic. So we held 3 in-person public hearings. You can see there on the screen, one in Albany, one in Buffalo, and then one in New York City. And we also held, and Chell, if you could go to the next slide, please. We also held a number of remote listening sessions. And these were rather unique. Obviously, we were in a time when much of the work was being done remotely. So there were a lot of folks that could not appear in person. So we had upwards of 35 remote listening sessions that were more focused on an individual area of practice or an individual interest that folks might have in our justice system. They were all led by members of the Pandemic Practices Working Group. This, again, I said it earlier, I'll say it again. I can't say it often enough. This group was extremely engaged. Every single member of the group participated in these remote sessions. So with all of that, we heard from upwards of 300, more than 300 individuals across the state and entities that wanted to express their views on how we did during the pandemic. So, Kel, if you could go to the next slide, please. So we made several observations, and time doesn't permit us to go through each of these individually. I hope you'll have a chance to take a look at our report, and you'll see them set forth there with more detail. And these observations, by the way, were not all complimentary. There were many things, as all of you know, if you participated in our process during the pandemic, there were many things that, frankly, we didn't really do very well. The courts never closed, but we certainly limited access, perhaps more than we should have, and hopefully more than we will as we face these issues in the future. I want to focus on, because I do want to be mindful of my time, I want to go to the recommendations if we could, Chell. So if you could go to slide 10 and then slide 11. So in addition to the observations that you'll see in the report, we also made 14 recommendations. And I want to emphasize to all of you, this process was extraordinary, not only because of the diverse group that was involved and the depth and the breadth of the folks that we heard from, but also the consensus that we reached. If you go back, and I don't want you to, Chell, because I'm almost out of time, but if you were to go back and look at the membership of this group, prosecutors, district attorneys, commercial lawyers, court system officials, etc., you might be somewhat pessimistic that that group could ever reach a consensus on anything. But we reached a consensus on 14 significant recommendations. And I want to, again, I can't go through all of them, and I apologize for that, but I want to focus on one in particular that I think is probably of greater interest to most folks. And that's the expansion of virtual proceedings, or the use of virtual technologies in the business that we do in the court system. So, Chell, if you could just go through slides 12, 13, and 14 and 15 slowly. And as you're looking at these slides, these are the guidelines that our group recommended to the court system in terms of which proceedings should be virtual, which proceedings should be in person, which proceedings perhaps could be a hybrid. And you can see that we got fairly detailed based upon the various stages of proceedings within each court type, broken into criminal, civil, and surrogate, of course, as well. So I'll leave that to you, for our audience to look at your leisure, but you can see that these guidelines are fairly significant and would be quite a change to our practice, of course, in the expansion of the use of virtual technology. We also, Chell, if you could go to the next slide, we also provided, because we need to be flexible, of course, each case has its own unique characteristics, each court, each judge, the geography of the state. So in order to assure that we maintain discretion at the level of the proceeding to the officer presiding, the judge, or the referee, we provided some suggested guidelines that could be applied if the presiding official wished to deviate from the guidelines. So if it's a suggested virtual proceeding and the judge wanted to have the proceeding be, or the lawyers wanted the proceeding to be in person, we suggest some factors or some considerations that might be relevant. So I know I'm running out of time. I apologize for being so quick, but I want to get to what do we do now? So we formed, with the blessing and the encouragement of then Acting Chief Judge Canatero and then Acting Chief Administrative Judge Amaker. And I should say that the new leadership has also been extremely supportive of our efforts. We created the Court Modernization Action Committee. And this group, again, Chell, if you can turn to the next slide, the membership of this group is somewhat similar to the Pandemic Practices Committee, but there are also differences and some additions. And you can see that we have vigorous representation from across the state, very diverse group representing areas of practice and court types so that we can move forward with implementation. None of us wanted to leave this report on the shelf to gather dust. We all felt very strongly that we had to be aggressive and vigorous and take advantage of this opportunity, this moment in time that we have to make changes in our court system and to learn from our mistakes, and frankly, not to go back to the old way of doing things in many respects, which I think most of us agree needed to be changed. We just needed a little bit of a pandemic to catapult us into the mood to make the change. So these are the members of the committee. And one last couple of last slides I want to show everybody. We broke the committee into task groups. So these are the task groups. So we've taken each recommendation of our group, broken the recommendation down to action items, which Jessica Cherry will address in a couple of moments. And we've taken each of those action items and assigned them to a task group. You can see them there. You can see who leads each task group. Again, we are fortunate to have superstars leading this effort, such a broad consensus, and really good fortune that we have this momentum and we have this agreement across the board. The final thing I'll mention before I turn it back to Judge Stein, and I apologize, I did go a little bit over time. The final thing I want to mention is the importance of continuing consensus and the importance of continuing to listen to and to interact with the stakeholders in this business. And importantly, bar organizations, access to justice organizations, the courts, etc. Everybody has an interest in making sure we do this right. This committee and this effort stands on the shoulders of a group that is intended to have this consensus continue. And it is our mission to try to build on that momentum as we move forward. I apologize for going over time, Judge Stein. That's all I have for now. I'm happy to take any questions later on.
Thank you, Judge Doran, and you should never apologize for going over time. What you have to say is very, very important to us. But I think what you have just laid out for us in record time, really, for all that you've done, it leads naturally to our next speaker, and that's Jessica Cherry.
Hey, good afternoon. Thank you, Judge Stein, and thank you to the Albany Government Law Center for hosting this event today and inviting us all to speak. This means a lot to me as a proud Albany Law alum myself, like Judge Doran. So again, my name is Jess Cherry, and I am the Deputy Counsel for Civil Practice and Legislation in OCA Counsel's Office. I am also a member of the Pandemic Practices Working Group, as Judge Doran set forth. And I am also a member of the Court Modernization Action Committee, or CMAC, as we'll be calling it throughout this discussion, which is charged with assisting in the implementation of the Pandemic Practices Working Group report. So within CMAC, I'm a task group leader for the legal task group. And I also serve on the Rules and Policy Task Group, which is led by our acting counsel, Anthony Perry. In addition, there are also task groups within CMAC, as you saw in the slideshow that Judge Doran set forth, on the subjects of training, technology, court management, and they are all engaged in this implementation effort as well. All of these task groups are regularly reporting their progress to the larger CMAC group that meets regularly. These task groups are still relatively early in our deliberations at this time, and I can only really speak today fully to the work of the task groups that I'm involved with, but I hope that I can provide just a brief general idea of the working group process within CMAC to date. So first, the task groups in CMAC have identified the portions of the Pandemic Practices Working Group report that require implementation, and we've identified what relates to each of our assigned issue areas. So in relation to the legal task groups specifically, which I'm the leader in, this will include expansion of virtual proceedings where appropriate, which Judge Doran has laid out a bit in his presentation, improving accessibility, public access to virtual proceedings, expansion of electronic filing, and also the issue of authorizations in lieu of affidavits. So once those specific action items were identified in our group, the task force has now proceeded to discuss just exactly what steps we need to take to provide any necessary recommendations or proposals or best practices in relation to those aforementioned issue areas. As far as the legal task group, we've identified, and as Judge Doran alluded to in the end of his presentation, that first and foremost, even though there's already been such extensive work done to hold public hearings and receive testimony and have these breakout groups in advance of the general Pandemic Practices Working Group report that was issued, we still need to continue to reach out to our relevant stakeholders and diverse practitioners in order to provide input and assist in promulgating these fully vetted recommendations. We're very committed to that. This outreach is including but not limited to the bar associations, the legal associations, the legal service providers, and also within OCA currently exists OCA advisory committees to the chief administrative judge. These advisory committees are comprised of practitioners across the state, academics, experts, judges, and they specialize in the areas of civil practice, criminal practice, surrogates practice, family law, matrimonial practice. We'll continue to seek the input of this broader legal community to help develop these best practices or any potential rule recommendations before we put them to public comment, and even statutory recommendations if and when those are needed. Specifically on the topic of statutory changes, which is my area of expertise, currently legislative enactment, as well as a critical need for budgetary support and technological investment, are our largest hurdles that we see to achieving progress and implementation. So speaking more specifically to the legislative enactment that's needed currently, at this time, the legal task group has identified 3 specific statutory changes that are required to aid in the implementation of the larger CMAC working group's goals. So I'm going to just go through them briefly with you. We don't have enough time to get in the weeds, but I'll just kind of give you the greatest hits here. First would be expanding the use of electronic filing. And since 1999, the unified court system has supported the introduction and the continued expansion of e-filing statewide and across case types. We have continually been able to extend e-filing authorization each year, traditionally or historically for 1 year, as it's a sunset provision that requires new passage every year, as well as administratively expand usage in more courts and matters. Most recently throughout family court, we've done quite a lot of expansion. Each year, OCA submits a proposal to the legislature that would expand e-filing to local criminal courts, district courts, city courts, town and village courts, and even allow requiring e-filing in matrimonial and Article 78 cases as well, in hopes of growing e-filing access statewide. However, last session, pursuant to Chapter 554 of 2022, the legislature and the governor effectively authorized status quo where we are now without no further expansion for another 5 years. So this signals to us ultimately that there is just no appetite right now among the legislature and the governor for expanding e-filing to additional case types at this time. Despite this 5-year expansion, we are hoping that we can still break through and perhaps get a statutory change going forward. The prospects, given that the legislative session ends June 8th, don't look great for this year, as our proposal has not been introduced, but we will continue to push as we always have. The second legislative proposal that's active currently is related to affirmations in lieu of affidavits. And presently, there is a proposal supported by OCA for several years, as well as myriad stakeholders and providers within the legal community, to amend CPLR 2106, which would allow affirmations in lieu of affidavits for all court users. And this is viewed as an important access to justice issue, given that issues that are with access to notaries statewide. Access to notaries, particularly in rural communities, as well as cost burdens of notarization that impact court users statewide. And also with new notarization statutory changes to electronic notarization that come with high costs, we're hoping to make affirmations instead of affidavits available to all court users to overcome this burden. Particularly in housing court, judges have shared their concerns that cases must be procedurally dismissed due to notarization issues. And operationally, we just support this change because it's just going to improve access to the legal system. We shouldn't be throwing out cases for that reason. The current bill number, for everyone's reference, of the live active legislation is S5162 by Senator Hoylman-Siegel. And in the Assembly, it's A5772 by Assemblyman Levine. It has passed out of the Judiciary Committee in both legislative houses. It is on third reading calendar in both legislative houses, which is legislative talk for it's ready to get passed. It's aged properly, it's ripe to go forward. We just need to get it on the floor. I'm told in the Assembly that it's on the debate list and ready to go. The Senate, I have not heard a similar assurance yet from leadership, but we are working. We have until the 8th, and hopefully we can make progress. And lastly, although this is not my specific area of expertise, there would also need to be statutory changes made to the criminal procedure law if we want to expand the use of virtual proceedings in the criminal context. So that is something else we are looking at within the CMAC legal task force presently. There are a couple proposals that exist, but we are vetting it currently. On a related note, while civil practice does not generally require legislative action to achieve this expansion of virtual proceedings, outside perhaps discussions of sensitive matters like family court and matrimonial matters, there are presently legislative proposals from the Bar Association, and I know from the OCA Advisory Committee on Civil Practice regarding the consent and framework for depositions being discussed. We kind of stayed away from depositions in our report, but I just want to bring it up because it is so important to the discussion of civil practitioners about this remote deposition question. So the CMAC Legal Task Group is exploring developing a general best practices for the use of virtual proceedings in the civil context. So with that, because I want to keep it brief, I will conclude by saying that obviously there is first and foremost a huge, as I said when I started my comments, budgetary investment in the courts that is required to improve technology and access in the courts on all levels to really make this a serious effort. But nevertheless, we are hopeful that even these small changes and recommendations in the immediate present will be a helpful catalyst for the improved access to the courts for the general public. So thank you.
Thank you, Jess. A lot to think about. And next, Judge Fisher, who I think we can say in at least some of her work would be considered one of the stakeholders. So we definitely are interested in hearing what you have to say, Judge Fisher.
Thank you so much. So I operate Legal Hand, which is an organization that has 3 call-in centers throughout the state of New York, and we hope to expand outside the state of New York fairly soon. There's one in Albany, Schenectady, there's one at Pace Law School, and there's one at Hofstra. Currently, I operate the one at Hofstra. And it was designed to be a call-in center because of the pandemic. Prior to the pandemic, it's always prior to the pandemic and post-pandemic. Our world has changed substantially. There were walk-in storefront centers operated by Legal Hand and the Center for Court Innovation. But those had to shut down during the pandemic. And so the founder of Legal Hand, in her wisdom, moved for the call-in center. So we've been operating since the pandemic, and what we saw during the pandemic were people in, crises, not able to access the courts because they, many people don't know how to operate teams and don't have access to teams, the more common forms of video or Google Meet or Zoom. And there's another one that I can't remember the name of. And so, there were struggles with people, actually participating in virtual proceedings, access to forms, access to notaries, getting their papers served. And what that resulted in is, some people not being able to, just have their day in court. But in some cases, although there was a moratorium on most evictions, there were some evictions going on. Some people got evicted because, they just didn't have the right access. And clearly landlords were affected by the moratorium, and we understand, but we serve both landlords and tenants and any other individual civil legal problems. So we see the full spread of legal problems that people are having. During the pandemic, you saw more people in, with mental strife, depression, calling in desperation, without any assistance at all, because even the legal services, legal aid programs were also struggling, and they were closed too. Post-pandemic, we still see some of the same problems. And, in terms of what I would suggest, in terms of future steps, and I applaud you for the wide range of people that you have on the committee, including William Moy, my friend from formerly the executive director of Northeast Legal Aid, but it's still lawyers, and they're still lawyers. And I think that lawyers, even if they're public interest lawyers, experience the court system a bit different than people who don't have lawyers. And so that you attempt to include grassroots organizations that represent people who are unrepresented, so that you hear the voices of those that are unrepresented, because they experience the court system differently. For example, and we get this issue all the time. I'll just give you an example. An attorney can issue a subpoena ducis tecum, right? An unrepresented person has to go to the judge, and the judge has to approve the subpoena ducis tecum and sign off on it. During the pandemic, that was difficult to get to a judge. Post-pandemic, the practices are so disparate from court to court and from judge to judge. We have come in contact with people who are unable to get a subpoena ducis tecum. And I can't go into the gory details, but we just don't have enough time. But, basically, there is no procedure in some of the courts, and there's no process. There's nothing on the website about it, so forth and so on. So an unrepresented person, just in terms of trying to get evidence together for their case, is going to experience it different than a legal aid, legal services attorney. So reaching out to grassroots organizations so you can hear the voices of their clients who've gone through the court system without an attorney, I think will be, it will be instructive for the future. I do have some suggestions going forward, but do we want to say that for questions, Leslie, or do you want me to just keep going?
Maybe if you want to just kind of give an overview, and then we can talk about them more specifically.
Sure. The affirmation in lieu of notarization, also key. I realize that requires, some legislative changes, but there may be some forms, like for example, the 130 form, that's a court form, that could be changed. Why does that have to be notarized? So that could be changed right away. The subpoena ducis tecum, subpoena process needs to be uniform throughout the state. We are the unified New York State court system. And so there should be a process for an unrepresented person getting a subpoena ducis tecum. What we saw also during the pandemic, and post-pandemic, are people who clearly needed guardian ad litems who were not being appointed guardian ad litems. And so that we need to do a much better job getting that done. Because even if somebody can participate virtually, if they don't have internet or they're elderly and don't know how to use the internet, they're not going to get access to justice. They're not going to get access at all to the courts. So guarding would be important. And I do have some suggestions about that. And also some suggestions about getting people more access to virtual proceedings. ADA compliance. Some ADA compliance is handled by the executive district executive officer. I forgot their title. Jessica, Paul Lamont is of the world. Chief officer, the executive district officer. I'm sorry, I've been away from the court for 6 years. I'm losing my lingo. And some are left in the hands of the judge. And I am a big proponent of judicial discretion and not taking judicial discretion away from judges. But some judges are not giving a very good ADA compliance. So I would suggest that the person who's in charge of the local ADA review the situation and make a recommendation to the judge at least. And then, the judge will do what the judge will do. But we've got to do much better job with people who are homebound and have other disabilities. I've seen some real horror stories of people who have lost their homes through foreclosure, partition actions, who clearly needed guardian ad litems, and they were either physically, mentally disabled, or both. And then a big issue in certain areas of the state, not uniform. In New York City, for example, in housing court, an unrepresented litigant can serve the sheriff, the marshal, and the other side themselves. They do not have to go through the steps of getting somebody else to serve or hiring a process server. In other parts of the state, that is the case. In Nassau, Suffolk, for example, you are not allowed to serve papers post commencement of litigation on your own. That is a problem. And there's really no need for that, given the fact that in other parts of the states, unrepresented litigants can serve the marshal and can serve the other side. This is post commencement of litigation. And part of the problem is that the CPLR allows the judge to do that, and on his or her own initiative to say you can serve the papers yourself on the landlord's attorney or whatever. But the forms themselves do not allow it. So it would take the initiative of the judge to strike it out and then add it. And the instruction sheets and the booklets all say you can't serve things yourself. So that would give better access to justice, but also would make access to justice uniform throughout the state. There's more access to justice in New York City than there is in other parts of the state. So those are some of my concrete suggestions, and I'd be happy to talk about it.
Thank you. I'm gonna go back to Judge Doran for a second and ask. I'm sorry.
Judge Stein, may I interrupt briefly?
Yep.
Thank you. For those of you who are seeking CLE credit, I have your code word to add to your affidavit of attendance. That code word is access. We've been talking about access to justice. Again, your code word is access, spelled ACCESS. Thank you.
Thank you. So Judge Doran, I'm wondering if you would just comment on what are the anticipated outcomes of implementing the post-pandemic practices working group's recommendation in the courts, and what we've heard a lot about the need and the commitment to having stakeholder feedback. What is the process that you are proposing, if you are, for doing that? Or, Jessica, you may want to weigh in on that as well.
So the process, and we've tried to be very methodical and systemic about this, is to continue the forward momentum and continue to build on the consensus. And building on consensus means involving stakeholders, and it means keeping them involved. And keeping them involved means this is not a top-down, this is not a few people in the room deciding how this is going to go for this great large state. This has to continue to be an inclusive, wide process. That gives us a lot of challenges, puts a lot of work on the shoulders of the leaders of our various task groups. But as you heard Jessica allude to, and the others would tell you the same thing, that every step of the way, we are an open book and we are fluid. Even though we're going to try to button things down and move forward, we also know that this is not a project that will really ever be done. I hate to say that, because modernizing the court system, addressing some of those concerns that Judge Fisher mentioned and so many others have, all of those things that our audience right now scratching their head wondering, why can't they fix that? Why hasn't the court system in the Empire State fixed its website yet? Why haven't we fixed our forms yet? Why don't we have technology in every courtroom so that we can continue to seamlessly move through whatever nature throws our way? We're endeavoring to answer those questions. The end game is to have many less of those head scratchers and to have the New York State court system be in its rightful place, which is a leader in the nation in modernization and access to justice. But we're not going to be able to do that with just a few people in a room pushing this forward. It needs to be a very fragile consensus process moving forward. And we do that by involving stakeholders. Judge Fisher just mentioned that we need to continue to listen to self-represented litigants. So one of the things that we plan to do as we roll out, for example, some of these technological improvements is to have focus groups with stakeholders, including self-represented litigants, so that they can share what their experience was. How did they like it? What didn't they like about it? What do they wish we would change? So that we're constantly evolving and going.
Thank you. And Judge Fisher, you mentioned a number of problems or challenges, and I'm wondering, some of them, it seems to me, have been around for a long time and in need of change. Are there any particular legal problems that you've seen change since the pandemic?
Sure. I mean, there's certainly much more medical debt. We're seeing them, and they're beginning to come through the court system now. There are, and it's just beginning to really hit now, more evictions, and it's not a matter of coming up with the money necessarily in some jurisdictions because there's no rent regulation. So when the landlord's done, and the person ends up evicted, there are no affordable places for people to go, so they end up homeless. More foreclosures and more consumer debt. We've seen certainly more of those kinds of issues. Some of it is due to the backlog of the moratorium with the evictions, but some of it is just because of people are at their rope's end. We are seeing, and this is of concern to me, we owe a moral obligation to make sure that people who are low income get, representation and access to justice. But I think what we're doing is overlooking what's happening to moderate income individuals, right into the middle class individuals who cannot obtain attorneys. One, because they can't afford it because they're still in financial strife from the, from the pandemic. They spent all their, their savings. or lawyers just won't take the kind of cases that they're beginning to have. They just don't do medical debt. They don't do consumer debt, that kind of stuff. And so the people that call legal hand are not always low income. We're getting teachers, firefighters, police officers, landlords, small landlords, not big landlords, small owners, calling because they don't have representation. They can't find forms to use, or the forms don't make any sense, or they're out of date, or the clerk's offices are giving them the wrong information. And, it's kind of, tough for me to say to the clerk's office, hello, you're wrong. I've done housing for 30 years. This is wrong. Trust me, it's wrong. And so the solution is not just more pro bono lawyers and more legal aid, legal services, which we have to do. Undoubtedly, because we barely, make a dent in representation for people who are low income. We have to figure out what are the measures that help moderate income people as well, because they're never going to get a free lawyer. They're never going to get a pro bono lawyer. They may not even get a low bono, and I hate that word low bono, where the lawyer gives a discount in their fees, and there are very few programs for that anyway. So some of the things that can be done don't cost money. Some of them don't, and some do. And so, for example, with the Supreme Court 130, that can be done with the administrative board, just getting rid of the notarization. That's quick. At least it's one form that people don't have to get notarized. The subpoena duces practice of how judges, how people get their subpoenas to the judges for the judge to approve should be uniform and standard and put on the website. It's not on the website. And I agree, Judge Doran, that the website needs, some changes. Some forms can be changed without difficulty, and some are more difficult. And so, getting them into plain language could be easier than it actually seems. And you could reach out to other people outside the court system to actually do the first draft and then have counsel's office go over it. So at least it's done. And then, it's sort of like a second glance to make sure it's correct. The ADA compliance thing, I don't think that's a big deal. I don't think that costs money. Have the executive director or somebody in the executive officer's office look at the ADA request from the person who's alleged to be disabled, and make there could be a form that the person that the exec just checks off and sends to the judge. This person's disability is this, and this is what the things can be done to give them ADA compliance. With respect to my concern about moving more towards virtual is that there's still going to be a segment of population that does not have access to internet. If they have access to internet, they don't know how to use it, or they don't know how to use the the programs. It's the elderly who don't know how to use it, don't have internet, only have telephones, and also people who are beginning to get rid of their internet because they can't afford to pay their rent and their food. So they get rid of the internet because they just can't afford to pay that bill. Internet's expensive, it's expensive. And if you don't have the money, you don't have the money. That there are other ways of giving people who are not, do not have internet or internet capability or ability, access virtually. If they're disabled, reaching out to a community organization that is willing to take a laptop to the person's home and put them on the site, when it's time for them to be in front of the judge. It could be a social services organization. It could be the Department of Social Services. It could be, or it could be a school program, like a social work program, or it could be some other kind of social services stakeholder kind of organization, so that the court could come up with some inexpensive Chromebooks to give to that organization to take out to somebody's home, so that the person can participate. It's particularly important for seniors and people who are physically disabled and not able to come out of the house. I mean, our recourse is not to have them participate in a proceeding, which I have seen happen. They just don't get to participate, and there's a default against them. So those kinds of things don't take money. It takes community outreach and finding the right organizations to give the Chromebooks to. As long as it's, Chromebooks are not that expensive, as long as it can do, a camera. You could buy a bunch of them for community organizations who will agree to go out to people's homes, or very close community hubs, where people can go to the public library, the police station, the church, the synagogue, the mosque, whatever, to open up a computer and have somebody help them get on to talk to the judge or the clerk, for that matter. I think virtual access to the clerk's office could be helpful too. And I know that's a lot for clerks, but that's a possibility. In terms of the website, Craig, I know it takes money to to redo it, but the time is now to fix it. But the forms, without the forms, most people are completely lost, who are particularly moderate income, because they can't get into court or they can't answer their cases. And of course, we need to move into doing more in different languages. We translate everything into other languages for people to read, but then they can't answer in their own language. So I don't know where AI is going to lead us to. I'm a little scared about artificial intelligence, but perhaps used the right way, it might work for us. If some maniac doesn't take over the world with it. So those are some quick suggestions in the time that we have.
Thank you. I think it's very important to look at this in a number of different directions. There are obviously a lot of obstacles and challenges to access to justice. And the question is and the fact is that, as you say, Judge Fisher, some of them can be addressed by the court system without any legislation, without funding. Although obviously personnel does cost, that's necessary. I understand that.
Yeah.
But so there are roles for not only the courts. Obviously, we've got a role for the New York State government. We've got a role for local governments and maybe bar associations, not-for-profits, community organizations, as Judge Fisher has indicated. I'm wondering, maybe just briefly on that, and also directly to you, Jess. What do you have a sense of what the legislature's resistance to some of these statutory changes, and in particular to expanding e-filing is? I mean, they've been talking about studying it for what, 20 years or something? What is the problem?
That's one of the issues that we face, is that we haven't really been given a great understanding or idea past of what the actual resistance is. For a time, the resistance, and at one point understandably so, was due to pro se litigants, and perhaps there was a presumption issue which was shifted, where pro ses may have to opt in right now instead of when they used to have to opt out. And also the issue of pro ses maybe feeling pressured to use e-filing by clerks of the court. We had some reports of. We tried to address that through training and through outreach, and we didn't really get a good sense that there was pressure being placed on pro ses, but we've tried to make it very clear that that should not ever be the case. So that's the extent of the resistance we've gotten in the past in terms of actual substantive response from the legislature. Beyond that, we don't really know. With the affirmations in lieu of affidavits, historically, it was there was, believe it or not, a sort of notary lobby of notaries at one point, which is kind of hard to conceive of it now. But and then some concerns about how do you find out, how do you verify, like, who, without notarization, and the courts do that process naturally. I mean, that's part of the process of a judge when they're reviewing a matter, and the attorney on behalf of the client, or even a pro se representing themselves, that they attest to that in filing their papers just equally as well through the affirmation. So that's the only resistance I've really heard. As far as Judge Fisher's comments, which I think are so true and so to the point, within OCA, I know we are working on the website improvement now, and plain language conversion. Forms, Judge Fisher, you couldn't be more correct. Form updating and enhancements, and there will be many more forms placed in front of the administrative board going forward, especially with our new leadership. That is going to be that is a commitment of OCA right now to make sure those forms are easily accessible and usable. And that is something that we can do now with little cost. I will say one of the hurdles we have had in the past few years, a lot of bills that have required a lot of excessive implementation, particularly in terms of data reporting. And that's occupied a ton of our DOT staff time. And so, we have a very long queue. Not that this is, not to be here making excuses, but our division of technology is having trouble recruiting. And it's been very difficult for us. We have a very long queue of and very limited staff. So we're working on that. That's part of this effort, is to, get these forms and these website changes moved up, so that, because Judge Fisher is completely right. People need that first and foremost, even before we get to inventory, which we all agree we need inventory of legal service providers. We really need to make it, we're in the Google age, so somebody should be able to get on the court website easily and figure out general parameters of what they should do. So yeah, that's where we are right now.
Yeah,
Go ahead.
I'm sorry, Judge. I would suggest maybe considering getting a committee of practitioners to draft the first draft of 1 or 2 or 3 forms, pick a form, whatever. You could have a housing practitioner, family practitioners, and have them do 3 forms, send them to a counsel's office to be reviewed. You at least would have at least a start in getting the forms done. And let's not go backwards. In a jurisdiction that will be unnamed, they just redid the forms. And they are not plain language. Even I had a problem understanding one of the sections of the form. So let's not put, we just redid that form and it's up on the website, and you have to use it because that's what's there, but that shouldn't happen. It shouldn't have. Going forward, it must be plain language, must be, or don't put them up. So maybe, a committee of people can begin to do it. I know OCA can't do it all. It's a lot of forms. I get it.
So in the very few minutes we have left, and boy, the time goes fast. There's so much to talk about, but we do have a couple of questions in the Q&A, and I'd like to try to get to them. Jill?
Yes, one of the questions, perhaps you could clarify. The recommendation, one of the recommendations was for mental hygiene law, Article 9 proceedings to be in person, according to the report in the slide. Are contested retention proceedings still virtual, or would they still be virtual under these recommendations?
So I'll try to take that quickly. There is much detail worked out. The item you're looking at, and if you look at the report itself, you might see a little more elaboration on the recommendation. But generally speaking, those proceedings that require in-person testimony, in other words, there's a necessity that somebody's credibility be evaluated. It was consensus that they should be in person, but there certainly could be exceptions to that. One of those exceptions might be that in a retention proceeding, for example, it would be dangerous to try to transport the person from the facility to the courtroom. So that would be one of the departing factors to consider the health and welfare of a party. So in that instance, depending on the circumstances, there would certainly be testimony in a retention hearing. But if one of those factors warranted a departure, then I would, and I preside over those myself. So I was just recently did consider health or the safety of the party, the subject of the proceeding. So these are guidelines. They're not even presumptions, they're guidelines, and that's an important thing to point out. But they continue to be understudied, and I want to make sure we mention and use my email, cdoran, DORAN, @nycourts.gov. Anybody in this space has suggestions, comments, criticisms, send me an email.
Okay, do we have time for one more question? I think we do.
Thank you. Yes, we have a few questions, so apologies, folks. We may not get to all of them. There are some questions about the filing process, particularly with regards to L&T filings throughout the state. Various courts have different policies, and it can be confusing. Are there any other aspects about the recommendations regarding the filing process that you'd like to share?
I don't know if somebody else wants to take that. I feel as though it's my responsibility since I'm the head of the group. And again, there are 60 or so, you add up all of the members of these committees that had a role in this. So I can't necessarily be the person that gives chapter and verse on each of the recommendations. I will say that there's a great concern that we need to have more uniformity so that litigants, whether they're represented by attorneys or whether they are self-represented, that there be some predictability and that we shouldn't make people guess from jurisdiction to jurisdiction, judge to judge. There needs to be more uniformity, but it's a balance. We don't want to be so uniform that we're removing the discretion of the hearing officer or the judge from doing what that person believes needs to be done with the proceeding in front of them. I see that Jess turned her mute off. So Jess can bail me out here on the detail.
Yeah. No, everything you said is correct. I just, from the perspective of, as part of my being civil, I do a lot of housing work in counsel's office. And one of the things we found during the pandemic is, the disparities in practice across the state were more glaring. And it is an issue. There isn't, like in New York City, upstate, a unified housing court. Different areas have their different practices. We are unified, not uniformed, as they say. And that is something, though, that slowly we're trying to address with statewide recommendations. And, it starts with best practices. And then from there, it goes on to hopefully statewide forms, which is our next step. And then from there, having, state, just a more cohesive way, because pro ses are the people in landlord tenant, particularly everywhere, who usually show up to housing court. And so they really need to know, no matter where they're located in the state of New York, that there's going to be a process that's similar. So that's something that we are continuously working on.
Well, I want to thank all of you for your input on this, and it's probably the most important thing. And I say thing, it's really a conglomeration of things that the court system has faced in quite a long time, and hopefully we will not let the momentum abate, and everybody will work to see that we do increase access to justice from the lessons that we've learned during the pandemic. Thank you all very much for your participation, and I want to thank Chell and Lisa and the rest of the Government Law Center staff and the Albany Law School staff who made this program possible. And thanks to our participants. Take care, everyone.
Thank you.
Bye-bye.
Bye.
Thank you all. I have a couple slides that I'll be showing as people trickle out.
Okay. Shell, if there are questions that weren't answered, perhaps we, the panel, would be happy to help, answer them in the, if you grab them. We can kind of post it somewhere if you want.
Yes, we have done that in the past. I will pull them from Zoom and share them with you.
All right. And Judge Stein, I'm sorry, I get on a roll and it's hard to stop me.
No, your perspective, it was exactly what we were looking for. We had the courts represented, and what you had to say was very, very important. So
All right.
no need to apologize at all.
Okay, I'm going back to the call-in center. Bye. Bye, Judge Doran. Goodbye, Judge Stein.
Hi.
Take care, Judge Stein. Thank you.
You too. Thank you so much. This is great. Absolutely great. Thank you.
Reach out. Feel free to reach out if there's any follow-up or any questions.
Okay, same here.
All right. Take care. Bye-bye.